Hello. Hello, good morning all. My name is Adil Patel. I'm the head of the employment department. With me are my colleagues, Piteni, Jillian, and Anli. We can't see for today. We have a full staff female panel to give us insights into yet again the state of disaster. What is different to the other presentations that we have done is when we previously spoke, there were regulations, there were directives issued pursuant to the Disaster Management Act or the Occupational Health and Safety. The Minister has now issued what is called a code pursuant to the Labour Relations Act. And what he has done is that he's consulted through neglect for updating this code. And may ask, well, where does this fit? This code takes in effect when there's a disaster.
Adil,
yes.
We're battling to hear you. The connection seems a bit scratchy.
Maybe then I should just kick off. The way that we are going to deal with this is that each of the colleagues will then just talk for 5 minutes, and then we can. Thank you, Pitini.
Pitini, I think you can take over.
Oh, sorry about that, Karishka. Good morning to everyone who has managed to join us for this webinar. My part really in today's discussion will be dealing with some of the key cases that have come up on mandatory vaccination. And recently, the Labour Court dealt with the distinction between what was termed by an employer the admissions policy versus a mandatory vaccination policy. And the court also considered, well, actually, this question was considered much earlier on by the CCMA on what is the status of the directions. And as early as that, the CCMA had concluded that the directions were actually subordinate law, meaning that they were binding law. And then this question also came about in the Labour Court in an urgent application that was brought by Solidarity, challenging an admissions policy. What that policy mainly provided was that from January this year, following an announcement made last year by the employer, any employee who wished to access the premises would be required to either produce proof of vaccination, or if they fail to do that, to provide a weekly negative COVID-19 test, failing which they would not be allowed access. Solidarity then went on to challenge the provisions of that particular policy, but interestingly, they argued that the introduction of that policy was in the first place a unilateral change in terms of conditions of employment. The court disagreed with that and held that they had failed to prove that claim. Then the court went on to consider what the status of the admissions policy was, and it is in that context then that the status of the directions were then considered, and the court confirmed that the directions were actually subordinate law and thus binding. However, in this specific case, the court found that the admissions policy was in fact not a mandatory vaccination policy. I will discuss some of the other key cases, but for now I will hand over to my colleague Jillian and Anli.
Thanks very much, Pitini. Good morning, everyone, and thanks for joining us today. I want to just deal firstly with the Code of Good Practice on managing exposure to SARS-CoV-2 in the workplace, which was published by the Minister of Employment and Labour on the 15th of March of this year. What's important to note about that code is that it's not yet in force. We still sit with a situation where employers are bound by the Consolidated Direction on Occupational Health and Safety Measures in certain workplaces. That's the Consolidated Direction that was issued on the 11th of June of last year, and employers are still required to comply with that code or that Consolidated Direction in managing the virus in the workplace. So what we need to then understand is what is the status of the code and why is that code being developed? So the Consolidated Direction, the 2021 direction, was issued by the Minister of Employment and Labour in terms of regulations under the Disaster Management Act. So what happened when the pandemic started was that government needed to manage the situation and it needed to issue regulations and directions to manage the state of disaster. So it relied then upon the Disaster Management Act to declare a state of disaster, and in the absence of existing legislation, the Disaster Management Act then allowed the government to implement regulations and issue directions. And the government has then relied on the provisions of the Disaster Management Act over the last 2 years, and since the end of March 2020, to declare the national state of disaster and introduce the regulations and directions to assist employers in managing the virus and the spread of the virus in the workplace. And as we know, the Consolidated Direction has empowered employers to introduce mandatory vaccinations in certain workplaces. And this drive now has been critical in increasing the number of vaccinated individuals in South Africa, curtailing the spread of virus and ensuring safe working environments. But what's important then is what is the situation after the state of disaster falls away, and how are employers equipped then to deal with the situation? Because as we know, the Consolidated Direction only applies for so long as there is a state of national disaster. And as we know as well, there's a drive amongst many for the government and pressure being placed on the government to lift the national state of disaster. So that state of disaster was declared on the 15th of March 2020, and it was initially anticipated to only last until June 2020. But as we're also fully aware, every month the government has been extending the national state of disaster, so on a month-to-month basis, and the latest extension is until the 15th of April of this year. And as I say, we're not yet sure when that state of disaster may be lifted, but it's anticipated that it may be as early as April of this year, 15th of April. With the decline in the number of individuals who are testing positive for COVID, with the decline in the number of deaths as a result of COVID, and with the decline in the number of people who are having to be hospitalized when they are infected with COVID, as I say, there is a drive and a push on government to now lift the state of disaster and move towards a period of recovery post the disaster era, and what we hope will then be a period of upliftment. We'll move from a pandemic into an endemic, or an epidemic rather, and a need to restore our economy. And so, as we've seen in many countries around the world, governments have been lifting the restrictions during lockdown periods, and it's hoped that in South Africa we can achieve the same. However, one of the important distinctions in South Africa compared to many other countries is that we simply haven't had the significant uptake in vaccination as we have had in other countries or other countries have experienced. While the government had hoped that we would have a situation where we would have 80% people fully vaccinated, at this point, they're less than 50%, it's about 48% as at March this year, who have been fully vaccinated in South Africa. As I say, despite this, there's this increasing pressure on government to lift the national state of disaster. And so we see the code now coming out, because what we need to deal with is a situation post the national state of disaster, but at the same time, we still have the threat of a potential fifth wave. And the code also addresses the concern that many employers have had that what is the value then of implementing a mandatory vaccination policy under the Consolidated Direction when the Consolidated Direction will fall away when the state of disaster is lifted? So as I say, the code is then the answer, because it allows for, as soon as the national state of disaster is lifted, the code will then come into effect. And we now have a situation under the code where employers can continue to have mandatory vaccination. What is interesting, though, is the code has been published under the Labour Relations Act. And before this, it was anticipated by many that there may be regulations published under the National Health Act or possibly under the Occupational Health and Safety Act. But despite that, the Minister of Employment and Labour has in fact issued or published the code, and he's done so under the Labour Relations Act, which specifically empowers the Minister to implement codes under the Labour Relations Act. So, as I say, a distinction between the direction, which was under, or the consolidated direction under the Disaster Management Act, and now we've got under the Labour Relations Act, the code being implemented. The code is, as I say, we don't know when it'll come into effect exactly, but it is an important indication of the preparation for the period after the state of disaster. And absent this code, we would then have a lacuna where employers could potentially not implement mandatory vaccinations or continue to impose that. But the code will now allow us to do that and fills that gap. As I say, there's an ongoing need for the code because whilst we enter into sort of a recovery period, there will still be a need to safeguard employees from the spread of the virus and members of the public with whom they deal. And that's why the code very much mirrors the consolidated direction in respect of many of the provisions, allowing, as I say, critically for mandatory vaccination policies to continue. But one of the other things it also does is give us and employers quite important clarity on certain provisions. One of the provisions that employers were concerned about was whether under the consolidated direction an employer could require an employee to disclose their vaccination status and specifically make disclosure of their certificate of vaccination. And where employees have pushed back on disclosing that information, employers have had somewhat of a concern about whether they can force that disclosure. And the code now expressly provides for an employer to be able to require employees to disclose their vaccination status and their vaccination certificates. I just want to deal just briefly with the purpose of the code, and that's dealt with quite extensively in section 2 of the code, which first off clarifies that it provides guidance to employers and employees as to how to manage the virus going forward and after the state of disaster is lifted. It also critically and as an obligatory requirement says that any person interpreting employment law must take into account the code. So any employer, employee, a judge, an arbitrator must consider the code. The code also sets out the Minister of Employment and Labour and the Department of Labour's interpretation of the law in relation to vaccinations, unless that interpretation is overturned by a court. So very important from that perspective. There's also some flexibility in terms of the code, recognising that employers' workplaces differ and the requirements of employers' workplaces differ. So it does allow, when the provisions of the code are non-obligatory, for an employer to deviate from the provisions. But that is quite restricted, and if an employer is going to deviate, it's got to have a justifiable reason for deviating from the code. What's important also to bear in mind is that we're not only dealing going forward and after the state of disaster is lifted with the code, but also with an amendment to the regulations relating to the surveillance and control of notifiable medical conditions. So on the 22nd of March, the Minister of Health published a proposed amendment to the regulations. This is now out for public comment over the 30-day period from the 15th of March. People can now comment on this regulation. What's important in terms of the regulation is that it provides for doesn't expressly refer to COVID-19, but because since the pandemic started, the department has declared COVID-19 as a category 1 most serious notifiable medical condition, along with yellow fever and smallpox. The code does, or rather the regulations do deal with COVID-19. And very importantly, it provides that any person with a confirmed or suspected case of a notifiable medical condition, which would then include COVID-19, may not refuse to submit to mandatory prophylaxis, treatment, isolation, or quarantine. And there has been quite significant outcry and relational response to the proposed amendment, to the extent that it's seen as potentially imposing mandatory vaccinations. And one of the important parties, or one of the parties that's come out quite vocally in response and condemning the regulations, is Trade Union Solidarity, who's expressed the view that this proposed amendment is not well thought out, and critically that it will place us in a situation where we will be in a state of permanent disaster. So that's just some of the important feedback in relation to the proposed regulation. If I can then hand over to Anli.
Morning, everyone. I'll be taking you briefly through some of the changes of the old code versus the new code. And when we refer to the old code, we're talking about the directive that was published on 11 June 2021, and that has formed the basis of any decisions regarding mandatory vaccination up until that point. When I talk about the code is now the new code that's published, which will take effect as soon as the national state of disaster comes to an end. The question that we've been asked regularly over the past 2 weeks is, how does the code differ from the directive, and what do employers need to do to ensure alignment with the provisions of the code? There are some changes, but not significant ones. It's also easy to address these internally. One of the most important things I think to note is that reasonable accommodation and the definition of what constitutes reasonable accommodation has not changed. That's important because the old definition was aligned with the Code of Good Practice on treating people with disabilities, and because the new code has the same definition, it means that to the extent that you as an employer have adopted certain measures to reasonably accommodate those who cannot be vaccinated or alternatively are too vulnerable to return to work, any actions which you may have taken in relation to that would still stand and would still meet the test, as the test remains the same. The new code also places an emphasis on a risk assessment. Now, all employers are required to undertake a risk assessment in terms of the directive, and the new code just emphasizes that once more. At most, what we anticipate may need to be done is that employers should evaluate their old risk assessments against the provisions of the new code to ensure that they have now, in fact, complied with all of the provisions as set out in the code, and that they've dealt with all of the items listed in the code. What we've noted is that on a first reading of the code, it seems that there may be some additional requirements in terms of which a risk assessment would need to be done. But once you look into your own COVID policies, we anticipate that these items may have been addressed already. An example is the reporting of symptoms by employees and isolation of employees who are diagnosed with COVID-19 and are symptomatic. Although that was not specifically listed in the directive previously, we anticipate that most risk assessments would comply with those measures in any event. But we do encourage employers to look at paragraph 6.1 and 6.2 of the code to ensure that their risk assessments comply and to see to what extent their risk assessments may need to be updated. Then the question that arises is the one of consultation. So there was an obligation to consult with your trade union on the risk assessment in terms of the directive. The obligation in relation to consultation remains unchanged, and to the extent that you're doing an updated risk assessment, you'll need to consult on those provisions as well. There's no requirement for the trade union to agree to the provisions, but there is a requirement for engagement, and to the extent that you've undertaken that exercise in terms of the directive, a similar exercise would need to be undertaken in relation to an update. The code also still acknowledges this requirement to have employees vaccinated. So it doesn't do away with the basis for a mandatory vaccination policy. However, it does say that your employees must be counseled on certain items, just as the directive did. Interestingly, what the code does is it doesn't list the grounds on which an employee may object to a vaccination. So previously, you may recall that an employee could object on medical or constitutional grounds, where the new code makes no specific reference to the grounds on which an employee may object. In our view, that doesn't mean that an objection can be lodged on any ground. It also doesn't mean that there is not necessarily a ground to lodge an objection against the vaccination. And we recommend that the old approach, as set out in the directive, still be complied with, in that any objection based on constitutional and medical grounds be properly considered before any next steps are taken. Interestingly, the code also now requires employers to assist employees in accessing the vaccination certificates online and to provide transport to and from the nearest vaccination site. So this may be as a result of some employers who have noticed that their employees have not necessarily always been able to access the vaccination certificates when the employer required it, and now the code places an obligation on you and the employer to assist your employees in doing so. Very importantly, and that goes to one of the questions that have been raised already, is the code now specifically allows an employer to require its employees to disclose their vaccination status and to produce a vaccination certificate. So unlike in terms of the directive, the code now allows you as the employer to make that request for a vaccination certificate where there was no specific basis to do so previously. The requirements to allow an employee to be counselled remains unchanged. If an employee refuses to be vaccinated, the employer must take steps to reasonably accommodate the employee in a position that does not require the employee to be vaccinated. On a first reading, that may seem that an employer no longer has the authority to decide on whether or not employment should continue in the absence of a vaccination. However, in our view, this provision should be interpreted exactly as the directive was interpreted, in that an employer must give regard to reasonable accommodation, and those items must be considered in detail during any incapacity inquiries before a decision on termination can be made. I'll now hand over to Pateni to just take us through some of the case law before we discuss these items in detail.
Thank you, Annelie. Just to pick up on the requirements of the June 11th, 2021 directions, interestingly, in the solidarity matter, just for convenience, it is solidarity on behalf of members as well as the specifically affected employee, Ms. Johetta van Rensburg, versus Eneslo, a division of Udego Trading Pty Limited, and this was a decision of 9 February 2022. One of the points that Solidarity raised before the Labour Court was, firstly, the admissions policy which had been introduced constituted a mandatory vaccination policy, and to the extent that the employer had actually not followed the steps set out in the directions, it made the introduction procedurally unfair. They took it as far as saying that the conduct of the employer was unlawful. Now, obviously, after having evaluated the facts, the court came to the conclusion that the admissions policy was distinguishable from the mandatory vaccination policy. It held, or rather endorsed, the position adopted by the employer that the admissions policy was introduced in terms of Section 8 of the Occupational Health and Safety Act, and it could distinguish that specific policy, even though it prohibited access from its premises to any employee who had not been vaccinated or failed to produce a negative COVID-19 test. I see in the question section, a question has come up on whether or not the requirement to produce a negative COVID-19 test can be introduced as a reasonable or valid alternative to full vaccination. Now, that came up in the CCMA on at least 2 occasions, which was firstly in Teresa Muldeate versus Gold Rush Group. Now, briefly, the facts in that case, it was an arbitration award. The facts, the employee had refused to be vaccinated after the employer had introduced a mandatory vaccination policy. She stated amongst the reason for refusing to be vaccinated that nobody could guarantee that she would not die and that there was no 100% proof that vaccination was helping or not. Now, she was called to an incapacity inquiry where the chairperson found that she had been permanently incapacitated. Now, this was on the basis that by refusing to be vaccinated, she thus could not perform her duties in line of her employment contract. The CCMA found in favor of the employer, holding that indeed she had permanently become incapacitated. Therefore, her dismissal in this instance was fair. A second decision was Gideon Kok versus Ndaka Security Services. Now, the basis for challenging the mandatory vaccination policy was slightly different. In this instance, Mr. Ndaka had been refused access to the workplace on the basis that he had refused to be vaccinated. He raised his Christian belief, and he also raised the fact that he had previously taken medication for a different condition. And as soon as he stopped, he was no longer ill. So simply put, he said that the medication had made him sick. However, the moment that he stopped taking the medication, he was fine. Therefore, he opted to rely on his natural immunity. Now, Ndaka was servicing Cecil, and one of the key requirements by Cecil was that everybody who accessed their site had to be fully vaccinated. They required 100% vaccination rates from all service providers, including Ndaka Security Services. Mr. Ndaka then went to the CCMA claiming that he had been unfairly suspended, so he filed this as an unfair labor practice dispute. Now, the question came whether or not prohibiting him from accessing the workplace amounted to suspension. The employer disagreed and said that they simply said he must stay at home until he is fully vaccinated or is able to provide a negative COVID-19 test, which would obviously be at his cost. The CCMA ultimately concluded that that conduct by the employer constituted a suspension. Then it went on to deal with whether or not such a suspension was fair. The CCMA rather considered Mr. Gok's argument that there was no law that obliged him to be vaccinated, and the implementation of the mandatory vaccination policy was in breach of his constitutional rights. Now, considering the first question of whether or not there was no law requiring him to be vaccinated for him to be able to access the workplace, the CCMA held that whilst indeed he had been correct on that, the directions instead allowed an employer to impose a requirement for purposes of accessing the workplace, and such a requirement was not unlawful. It went on to consider the individual circumstances, the fact that he claimed that there were others who had not been vaccinated but were allowed access. And the response by the employer was that those specific individuals could be reasonably accommodated, firstly by requiring one of them to stay at home, another one could perform their duties in an isolated part of the workplace. However, this particular employee had to interact with the client, had to interact with various employees. So it was really impossible for him to perform his duties remotely or in an adapted manner. And his refusal to be vaccinated was unreasonable. The CCMA then concluded that his suspension in this instance was actually fair. I've already dealt with the Labour Court decision, Solidarity, challenging the imposing of the admissions policy. That concludes my presentation on some of the key cases on this issue.
Hi, good morning. I am back and hoping that I can be heard clearly and succinctly, having moved from the previous place that I was sitting at. What is fascinating from the code for me is if you take the code and you compare it to the code of good practice on dismissal, you would see that the code is rather prescriptive. You will be able to see government's anger embedded in the code, and I'll take you to the specific sections there. You can ascertain from the code government's thinking. And why do I mention this? So, although there is, and debatable at this stage, that there is no specific legislation mandating employers to compel employees to be vaccinated, a mandatory vaccination. Government is certainly encouraging or wants employees to be vaccinated, first thing. Two is, given the case that Peteni had raised about from the Labour Court, which regarded the directive as subordinate legislation, there is certainly an argument that currently the directive authorizes you to compel employees to be mandatorily vaccinated. That's certainly an argument. But when the code comes into being, and just to read to you what it says, to the extent that this code advances an interpretation of the law, that interpretation is the policy of the minister and the department, and should be applied unless that interpretation is reversed by a decision of the courts. That's quite a prescriptive statement by the department. The next one, it says, apart from those provisions of this code that reproduce the obligations contained in employment law, the code is intentionally general because workplaces and their requirements differ. And this is the important part. Departures from the non-obligatory provisions of this code may be justified in appropriate circumstances. Any employer or employee who departs from them must demonstrate justifiable reasons for doing so. The Labour Court has said the following in relation to Code of Good Practices issued by the issued pursuant to the Labour Relations Act. There are guidance. You must try and comply with it to the best of your ability. What we have now is that the department is indirectly making it obligatory to comply with the code, and if you wish to depart, you need to be able to illustrate to a court of law or to the CCMA good reasons why you've done so. So firstly, you need to say, this is the code. I've departed from it because of these reasons. If they find that your reasons are not justifiable, they may find you in breach of it and may find any action to be unfair. Compare this code to any other code that's been issued, and you're not going to find a statement like this. It's rather onerous. So what is our view? Our view is they are compelling you to adhere to a strict compliance of it, because if you don't adopt a strict compliance, you need to be able to illustrate justifiable reasons why. Now, let me pose to Anli the following question. There is this concept of reasonable accommodation, and it comes out in the questions and answers in the questions as well. Well, my employees can work from home. We've been working from home for 2 years. So a reasonable accommodation measure is that employees can permanently work from home, and therefore you can't ask them to be mandatorily vaccinated. And the question that I pose to Anli is whether the permanent or indefinite working from home can be regarded as a reasonable accommodation measure. Thank you. Anli?
Thank you, Adil. So whether or not something constitutes a reasonable accommodation measure should also be tested against whether or not it constitutes an unjustifiable hardship to the employer. And I think that's important to remember, because during any inquiry or discussion where reasonable accommodation measures are being considered, the requirements of both employer and employee must be taken into account. So if there's a requirement on the side of the employer that needs the employees back at work, be that for a very limited period of time or on a very reduced scope, and the only possible solution being proffered by the employee is that they must be entitled to work from home indefinitely, that doesn't necessarily pose a solution. I think what we've seen happen in the past few months is that employees have adopted an approach where they object to mandatory vaccination policies or make requests to be reasonably accommodated. They make a general submission as to why they should just be required or permitted to work from home indefinitely. In considering those, my advice would be for the employees to consider that your employer has a right to request you to return, and for the employer that you have a right to consider why it is important to you to have your employees back at work.
Thank you. And I think just to unpack that, so when we are going to when you're leading evidence, your HR people and your organizational design individuals are going to be of paramount importance to be able to illustrate why having somebody permanently working from home is not a reasonable accommodation measure. You're going to have to give evidence to show how does it affect your culture? How does it affect training? How does it affect being part of your organization? Let me then just touch on where we are from a legal development perspective. Pettini, we know that Solidarity has challenged the University of the Free State with their mandatory vaccination policy and brought some sort of applications. Do you just want to take us through some of the cases that, apart from the ones that you've mentioned, that have been unsuccessful at court, and if there's any feedback on the issue from Solidarity and the University of the Free State? Thank you. Yes. Maybe just let's just move on. So just before I come to Gillian, this issue of do PCR tests constitute a reasonable accommodation measure and who pays for it? There has been a hot debate within many circles. So just to give us some insight there.
So the payment is being disputed by, so whether or not it may be paid for depends on the circumstances. But the payment is being disputed in some instances with reference to the code and the directive, both of which contain this provision, which I'll read to you. It's section 16 or paragraph 16, and it says that no employer may make any deduction from an employee's remuneration or require or permit an employee to make any payment to the employer or any other person in respect of anything which the employer is obliged to provide or to do in terms of this code. So the reason why we're of the view that paragraph 16 won't put the debate to bed about payment of PCR tests is because a PCR test is not something that an employer is required or obliged to do. So to the extent that it's asking employees to pay for it, that payment can't necessarily be challenged on the basis of paragraph 16 of the new code.
The question is section 16 of what? It's item 16 of the code as such. I'm just not sure whether Pettini has been. From the definition, there was is there a change in the definition of vaccinated based on the directive? That you've come across? What was the definition of vaccinated under the regulations, and now what do we have that from a code perspective as such?
Yeah, so Adil, I mean, expressly now under the code, there's a recognition that we enter the period now where hopefully many people are getting boosters. So fully vaccinated or vaccinated is defined as having your either 2 or 1 jabs plus the boosters. So, if your policy is silent on what constitutes vaccination, then potentially once the code is in effect, you can rely upon the code, which refers to vaccination as actually having your boosters as well.
Then just to touch on item 15, and just I'm throwing it open. This consequence about a refusal to work under where you believe that it poses a health and safety. And let me just map the scenario. Within the mining industry, sort of about 5-6 years ago, employees refused to attend work because they believed that they felt unsafe. And what does that mean? There was union rivalry. They were scared that they were going to be attacked and killed, and some of it was justified. And they relied on the Occupational Health and Safety Act as a basis to say that they will not come to work because you as the employer have not created a reasonably safe working environment. We see some of that thinking now been reflected in the code, and it has also been in the directive. And we see that at item 15, where it says that an employee may refuse to perform any work if circumstances arise with reasonable justification, poses an imminent risk to it, and then it has some sort of dispute resolution procedure within that. Only Jillian, do you just want to take us through item 15 and how does that follow through as such? Thanks.
Yeah, Adele, I think what's important about that refusal to work and the provisions of that section 15 is that an employee has an obligation as soon as they are concerned about their safety in the workplace and they feel that there's a threat of the virus in the workplace and the employer isn't safeguarding or creating a safe working environment, that the employee must notify the employer of that, and that there must then be intervention as quickly as possible to try and alleviate the concern of the employee. And also, if it gets to the point where the employee is still not satisfied, that a labour inspector is then called to come and do an inspection. So I think what the measures they are to try and address it as quickly as possible. And what's also critical is that an employee can't be disciplined or dismissed for raising this kind of concern. And if there is a dispute about it, that it's got to go to the CCMA. So a mechanism to try and deal with these disputes quickly without resorting to industrial action, but rather to go through a process of arbitration, conciliation first, and then arbitration at the CCMA to resolve them as quickly as possible. So I think also, you know, to your point earlier, Adil, about this code really being very different from other codes where we've got a very sort of flexible approach. This code very much speaks to obligations under OSHA and making sure that those obligations are clearly set out for employers and that they're obliged to comply with those requirements. So whilst the government is obviously trying to ensure as much as possible that there's a drive to vaccinate and that there's pressure on people to vaccinate, there's also ensuring that employers comply with their statutory obligations. And we see again in this code as well, a reminder that if an employer doesn't comply with its OSHA obligations, once again, this code speaks to the offences and penalties that employers may then face under OSHA, which, as I say, are mirrored again and referred to in this code. So, you know, balancing the drive to vaccinate and at the same time to ensure that employers discharge their obligations and also to avoid industrial action over these kind of matters, but rather going to arbitration at the CCMA.
And just to touch on that, what is important and what has caused some consternation amongst employers, there's a provision under item 15, which says, no employee may be dismissed, disciplined, prejudiced, or harassed for refusing to perform any work as contemplated in subsection 1, and that where you believe there's an imminent and serious risk of the exposure to SARS. And employees have said, well, if I raise an issue that you are posing an imminent threat to me, the minute I pose that, the minute I raise that issue, you can't dismiss me. But that cannot be the interpretation. It simply says that I can dismiss you. If you don't want to work, I, as the employer, believe that I've taken reasonable steps, I can terminate your services. You can thereafter refer the dispute to the CCMA in accordance with item 15 and say that I have been unfairly dismissed. I raised the issue regarding my work environment. You as the employer must justify why your reasons, why the employee's reasons for not wanting to work was not justifiable as such. And that's quite an important point, because some employees initially, when this was reflected in the directive, employees were saying, well, you can't dismiss me. But that clearly may not be the correct interpretation. Peteni, welcome back. Do you just want to take us through the Solidarity University of Free State, if there's any feedback on that sort of litigation and all the other urgent applications that have been brought to court, and what has been the outcome from your side? Thank you.
Thanks, Ardell. So just briefly on the solidarity versus the University of Free State matter, it again concerns the mandatory vaccination policy now requiring both employees as well as the students to be vaccinated. Interestingly, despite challenging the mandatory vaccination policy, Solidarity has come out saying that it is not necessarily against the vaccination or requirement to be vaccinated as an intervention. What they are against is requiring everyone without necessarily considering their individual circumstances to be vaccinated. They issued a statement saying that it is important for employees, including the university in this instance, to conduct a proper risk assessment and to look at each individual and whether or not alternatives can be made to accommodate them. And in this instance, we're talking hundreds or thousands of students, looking at each and every one and what their reason for refusing to vaccinate is and whether or not alternatives can be made. And that insofar as I have followed the court matter, there hasn't been direction, but this builds up on the earlier case that I dealt with. In fact, Solidarity in that case said, listen, we're also not against mandatory vaccination, but what we do require is to consider the individual employee circumstances, and if there has been an application for exemption filed, what are the reasons for exemption for them seeking exemption, and can their duties or the workplace be adapted to accommodate them insofar as they refuse to be vaccinated for whatever constitutionally recognized reason. And that's really insofar as I've managed to track the developments in that front, but I'll obviously be keeping my tabs on it to see what the outcome of Solidarity's challenge. It has threatened to challenge this in almost every university in South Africa. In their website, they do state that they've received over 300 requests to challenge mandatory vaccination policies being implemented by universities.
Anli, thanks, Petini. Anli, does the code require us to do a new risk assessment, or yes, so how do we go about doing the risk assessment if we've done one already under the directives?
So the first thing to do would be to consider whether you've done a risk assessment at all. If you haven't, then that's a gap that should be addressed quite urgently. To the extent that you have conducted a risk assessment, to assess that and evaluate it against the provisions of the code to see and to confirm that you've now complied with all of the provisions that are required to be set out in the risk assessment. And then in doing so, your normal consultation obligations remain, in that you have to engage with your trade union and your health and safety committee on that risk assessment.
Good. Then, can I then just touch base on if an employee, and probably just open up to the forum, suffers from an adverse effect that renders the employer unable to work. So that's catered for under item 12.3. What are the steps that one takes, Gillian, if one suffers from an adverse effect after taking the vaccine as such? Thanks.
Yes, Adil, and there's specific provision then that you can, if you can establish that it's as a result of the vaccination, that the employee can then be given time off. And if they then are in a position where they need to make a claim, they can make a claim through UIF under the legislation for, if, as I say, if that's as a result of the vaccination.
And I must just say that the Compensation for Occupational Injuries and Diseases Act, pursuant to which you can lodge such a claim, has rather strict requirements as a result in order to satisfy the test. There's a question that says, are there any cases where an employer succumbed as a result of being forced to vaccinate? And if so, has this been litigated? I gather the question is, where you have a mandatory vaccination and an employee has initially refused, have they eventually acceded to your request? Yes, we have had lots of those employees, and no, there's no reported cases on that. A number of the cases that have emanated are as a result of employees being dismissed. Employees asking, just piggybacking on what Gillian says about the Compensation Act, employees that ask for, oh, you must give me insurance and the like. If I suffer an adverse effect or take out insurance, well, that's what the compensation, the Compensation for Occupational Injuries and Diseases Act is. There's a question which is more of a health question or a medical question, but worth mentioning. How are vaccinated employees not a health and safety risk to the organization? Why is it that they are not required to provide negative tests as well? You would understand that the vaccination, and this we traversing the medical arena, a vaccination does not prevent you from getting COVID. It allows you simply to withstand the severity of the virus, and when you spread it, it's not as potent as somebody that has that is not vaccinated. Good science, as of the 29th of March 2022, says that the vaccination remains, and this is internationally as well as from the World Health Organization, remains the most effective way to ensure that the COVID-19, the severity is not, sorry, the virus is not as severe as it was historically. Now, we have had a number of employees saying, I've heard, or I've read, or I've Googled. That's not good science. That's not what our courts are going to rely upon. Now, if you look at from an evidentiary perspective, and I think let's just spend some time the last 5-6 minutes. You have a mandatory vaccination policy, and this is to you, Betty. You have a mandatory vaccination policy. You take the individual through an incapacity and not an insubordination. So we know that there are views within the marketplace that says you can dismiss somebody once you have a policy for insubordination or retrenchment. The safest way, look at the cases, it's one of incapacity. Now you need to defend that claim at the CCMA. Jenny, just practically in the last 5 minutes, what evidence or how does an employer prepare to defend such a claim? Thank you.
Thanks, Adil. So very importantly, as we've highlighted, I think, throughout this webinar, is the importance of having the rules in place and communicating the rules. The commissioners at the CCMA have always asked the question, which is really not a new question, is there a rule or workplace policy in place? Now, interestingly, in one of the cases I came across involving a law firm, the rule was not necessarily in writing. It was, however, communicated constantly in staff meetings. And the CCMA held that that sufficed because even the employee did not deny that that requirement to be vaccinated was communicated in clear terms and he had been aware of it. So that is number one. Number two is on the procedure. What did the employer do when the employee refused to be vaccinated? And also importantly and interestingly is in this particular case involving a law firm and a candidate attorney, the CA said, well, I've read or I've learned from reliable sources that I cannot disclose that it doesn't guarantee that you'll be safe. Now, when he was called upon to bring the information forward so that it that can be evaluated. He said, I can't because I knew that my employer would not take it seriously because it's not been confirmed in scientific terms. So again, when somebody says, I cannot be vaccinated, what are the reasons? And if they applied for exemption, has it been evaluated? Was the outcome communicated? That also goes back to the question of if the reasons are valid, is alternative accommodation reasonable or possible? And if not possible, was that communicated to the employee? We go to the issues of can the workplace be adapted? The employee, in this instance, the CA, asked to share a desk with the reception. And obviously that was not reasonable because reception is where you interface with clients. He was going to be in contact with other employees as well as clients whilst at reception. That was not feasible. He also could not work from home because at that point his firm was involved in the Zondo Commission and there had been a cyber breach at the law firm. So everybody needed to work from the office to minimize exposure and leaking of confidential information, which is also an important consideration when somebody works from home. Is there adequate protection in place from a cybersecurity perspective? That is one of the things that the CCMA has had to consider. What were the alternatives and were they possible? And if not, the CCMA has come out to say that if alternative accommodation is not possible, the employee has to at least conceive that dismissal would be inevitable because effectively they render themselves incapable of performing their services in line with the employment contract. So from an evidence perspective, it is important to have all discussions, all conversations that you have, whether informal or formal, to be recorded so that down the line, if there is a dispute on the awareness, counseling on alternatives, and what could be done for the employee and what could not be done is placed in question, the employer is able to lead evidence.
Thank you, Petunia. And I think what we mustn't underestimate, the medical evidence is of fundamental importance. Do not just take it that everyone accepts that vaccination is the most effective way to deal with the severity of the disease. The other component, just to add on to what Petunia says, remember the code requires strict compliance. You would need to show that you've done the risk assessment. You would need to show that you've consulted on the risk assessment, and you need to show that the employees that you have identified should be subjected to vaccination. Now, I'm going to leave you with this final thought. And if I didn't get to most of the questions, then I'm sorry, but please feel free to get in touch with us, our Anli, Gillian, Petunia, or myself. You see, the risk assessment says the following. Identify employees who should be vaccinated. But if you understand the concept of employees who should be vaccinated, it operates on this premise. It operates on the premise that you can physically do work from home and you never need to come to the office. So you could be running a potential cyber organization. And that can't be correct, because what every single employee should be identified to be vaccinated, because every single employee at some point needs to come to the office, whether for a day, for an hour or the like, because even if you adopt a hybrid model, you need employees at the office because you do not run a remote organization. So therefore, it is imperative that you look at your risk assessments and ensure that the people who you require to be vaccinated are identified in the risk assessment document, because the CCMA is going to ask for strict compliance. Clients, colleagues, and invitees, thank you. It is 9:30. I really like to thank Gillian, Anne, and Petunia for joining us. We hope this was informative. Please join us on the 13th of April for our sexual harassment webinar on the code, which has been implemented, and we're going to take you through practically how you need to amend your policy and the like. If you have any other questions, we've tried to answer as many as we can on the chat. We hope this was informative, and thank you for joining us. And this webinar will be available on our LinkedIn and on various other social media platforms. Thank you all. Goodbye.
Thank you.